A very good morning to all and a warm welcome to today's resource person first of all, and all the participants to today's webinar on behalf of the management principal, dean academics and R&D and faculty and the students. Today's webinar topic is Introduction to Patent Law, which is a very important and interesting topic, which is to be aware of. Everyone has to be aware of such a law. So mainly for those also BTech students who want to innovate something so newly, it must be so required. This knowing this law must be so required. So because the innovator can use such innovation, and also he can give license to others to use his innovation, and he can also books cases against the infringement of his innovation and etc. See, all these details can be discussed by our resource person elaborately. Yes, it is a very important and interesting topic. Now, first of all, our Assistant Professor Ms. L. Deepika, Madam will introduce our today's resource person to the participants. Deepika ma'am, so you can.
Good morning to all. Thank you for joining us for today's webinar. My name is Deepika Linganabaina and I am the Assistant Professor in Department of Management Studies and also a co-coordinator of IPSL. Guru Nanak Institute of Technology is a leading provider of education in Hyderabad. And today's Honorable Chief Guest Dr. Lakshmi Rajshekhar Garu and Head of the Department of MBA, Dr. B. Madhusudan Reddy Sir, Principal Sir, Dr. S. Srinath Reddy, Dean Sir, Dr. Sanjeev Srivastava, staff members and all the students present here, I welcome you all to the session on Introduction to Patent Law. I feel extremely honored to introduce the chief guest. Dr. Lakshmi Rajshekhar Garu has completed his graduation in the law and he completed post-graduation with the specialization of labor laws from the Nagarjuna University from Guntur. Out of passion, he completed 3 post-graduation programs in the disciplines of management, psychology, and human resource management. And he completed his doctoral degree from the management stream. Besides this, Dr. Rajshekhar has completed the postgraduate diploma courses in personal management and industrial relations, business management, and hospital and healthcare management. He has 25 years of expertise teaching a variety of disciplines in the fields of law, management, and engineering. He has published 19 papers in various national and international reputed journals and attended many international and national level conferences. Dr. Lakshmi Rajshekhar Sir is presently working as a professor and head of the Department of Business Management at Jyotishmati Institute of Technology and Science, Karimnagar. I guarantee that the webinar will be productive and worth your precious time. I am sure we will be enriched by this webinar. Now, without further delay, I am handovering the session to Dr. Lakshmi Rajshekhar Garu. Please carry on, sir.
Not audible, sir, your voice.
Sir, you.
Okay. First, actually, let me thank to the management of Guru Nanak Institute of Technology and the principal sir, dean, the coordinator, the head of the department, and the co-coordinator. So thank you for inviting me for the webinar on the introduction to the patent. So without making any delay, just I wanted to go for having a discussion on. So is it visible to you?
Yes, sir.
Okay, thank you. So now what we discuss today.
Sir, just Sir Rashid, sir, just change into presentation mode, sir.
Okay, okay, sir.
Click that.
Okay. So what we discussed today. So the most important concept in the today's environment, especially the technocrats as well as the management students, have to know about of what is just happening around the industry. Why? Because lot of connectivity of academia and industry as of now, because of the initiatives from the AICTE, UGC, as well as the autonomous institutions, they are coming forward in introducing of the intellectual property right related concepts for the technocrats, for the BTech graduates, as well as for the management students also. So today actually I wanted to concentrate on what is meant by the intellectual property and why the intellectual property is more important for the technocrats and managers. Why? Because as of now, to some extent, it could be said that it is ignorant from the techno students' point of view, where we are supposed to concentrate and what is lacking. Why? Because in the context of the startups also, I wanted to just throw the light on and what is meant by the patent. Okay, the definition part is more important, and the relationship between the patent and the startup. So, and how to protect actually the patent and the rights of the patent holder, the provisions under the different laws to protect the rights. So actually in general, properties can be classified into three: mobile, immobile, as well as intellectual. We have known the fact about what is mobile, what is immobile, but intellectual property in the today's environment is getting more importance. So the tangible in nature could be seen from the mobile and immobile properties point of view, but with regard to the intellectual property is concerned, it is an intangible property. So the person who is coming up with innovation or what's called any creation, so that it is going to be granted. Where actually this patent concept that we got? Actually, the GATT, General Agreement on Trade and Tariff, okay, once upon a time we got. So among the intellectual property rights, patent is only one of the rights and only one of the intellectual related aspects. If you trace back the intellectual property related aspects, in the year of 1947, a platform was created by the USA just in order to have the trade and in order to encourage the intellectual properties and its recognition. Since 1947 to India was a member nation since 1947 itself, and thereafter in the year of 1995 a new platform was created as a successor to the GATT. WTO was formed by including of the service related aspects also. World Trade Organization, it is an international platform to do actually the trade in between the different countries and honoring of the different intellectual property rights. Though we were the member nation in the 1995 of the WTO, but we made an application to the WTO to excuse ourselves in implementing of the intellectual property rights and its recognition. And since 1995 to 2000 and 2000 to 2005 also, once again, the excuse was just extended. And since 2005 onwards, the real intellectual property rights protection has begun in India. Among the WTO agreement, World Trade related aspects, the trade related aspects of intellectual property rights, trade related investments, as well as business related aspects. So three important aspects were covered. As of now, we are only concerning with the intellectual property rights. That is the reason why just I have taken only the TRIPS. TRIPS agreement was made. Look at actually different intellectual property rights are there. The first one is it can majorly be classified into industrial rights as well as the copyright. Among the industrial rights, industrial means that here the tangible in nature could be seen. the patents, the trademarks, industrial designs, and the plant layouts also can be seen here among the industrial designs. And the circuit designs also, it was an added concept, and the trade secrets or else undisclosed information related activities. The encircled R here, as well as the TMs, SM, and the encircled C that you are able to see on screen. Actually, the patent which is registered, the trademark which is registered, okay, the service mark which is registered. Registered means that approaching the government, getting the acceptance according to the rules and regulations, okay, then the government is going to grant a patent or a trademark or a design, industrial design, what's called related rights and the trade secret rights to you. So then only we could use encircled R, or otherwise, if I wanted to claim it as a trademark, okay, with regard to the trademark is concerned, trademark is nothing but an impression creating among the public and the society at large with related to a particular selling activity. So if I wanted to sell my product, is
sorry for disturbance.
Yes.
Please press F5, sir. It will go presentation mode.
now it is in presentation mode, sir.
Okay, sir. Right.
I think that okay, you might not be able to
Yeah.
see
Okay,
it.
sir.
Actually, it is in presentation mode only
Okay, sir. Okay.
on my screen.
Yeah.
Okay. So encircle C indicates of the copyright granted by the government. So unless and until you get the permission from the government, it cannot be protected. Of course, a few exceptions are there in this regard. So just before moving to actual discussion about, let me know the different authorities where actually we should approach with regard to our intellectual property rights are concerned. So as of now, our concept is of the patent. The patent head office is located at Calcutta. Okay, the other branches are at Delhi, Chennai, and Mumbai. Strategically, actually, the patent offices were located. Why? Because so once upon a time, actually, it were created, but as of now, when the more startups, because of the government initiative, central government initiative, when a lot of startups have begun, so the government, even central government, wanted to come up with more number of patent offices. So approaching the government. So even through online also, in the today's environment, one could easily make an application, move an application with related to any intellectual property rights through online. So that flexibility also what's called being given. But even then, the government is thinking to extend of its different what's called offices in the different strategic locations. And one other platform that we are supposed to know, the World Intellectual Property Organization. It is an international platform. Okay, any intellectual property right. Actually, two things that we are supposed to know. One is national level platform, and second one is international level platform. At the national level, actually, under the central government of India, Ministry of Commerce and Industry, it is launched in Indian Intellectual Property Rights Organization related website. We could easily access what's called every information, okay, relating to the updation, relating to what's called the filing of the patent, the granting of the patents, and the different other intellectual property rights. And in order to be protected through what's called at the international level, so the platform is created called as WIPO, World Intellectual Property Organization. It is one of the 15 what's called specialized agencies under the UN. So since actually 1970 onwards, it began its operational activities. So 90% above the countries are the member nations. It clearly indicates that how the countries are showing of their willingness to honor the intellectual property rights. And recent past, actually, most of the countries, they made the applications to be a part and parcel in the WIPO on the WIPO platform. And important aspect is that actually why to know the IPR, and especially the concept of today, patent related what's called the content, why we should know. So you might be an undergraduate of the technical profession or a management graduate or postgraduate. The need to know. The first one is knowingly or unknowingly, once we become as an employee of any organization, automatically when we undertake of the responsibility, when we forward what's called our willingness to work with the management. So in the agreement itself, some of the provisions clearly indicates that whatever you come up with your capabilities, so automatically the rights will be transferred to the employer. In the today's environment, the cutthroat competition, it means that lot of competition, what's called, can be seen among of the markets. Okay, so the employer, it means that your organization is compelled to move according to the requirements, according to the changing pattern, according to the changing customer needs and what's called expectations. The company should also move. So when it wanted to move in that direction, it is a compulsion on the part of the company to identify, develop, and what's called leveraging of the innovation, different what's called, to be on competitive edge. In order to be just ahead to the competitor, so one should involve in the R&D activities, or otherwise it is not going to be there in the market. Come up with new innovative ideas, new innovative what's called, components, new innovative, methodologies or processes through which only you could be there in the market, either to survive in the market for the new entrants point of view, or to continue in the existing market, or to get the growth. Certainly it becomes an inevitable, compulsion on the part of the employer. That is the reason why the employer, he compels you to go for innovation or to go for come up with new ideas. It means that whether you are willing or not, whether you know the intellectual property rights or not, but your employer requires it to be there in the market. That is the reason why he might compel you to undergo, to come up with new innovation, to come up with new idea, and under that compulsion, certainly we should move. And rather than what's called after becoming as an employee coming up with, so that is the reason why the recent changes, the private institutions and the different what's called government authorities, they are introducing of the intellectual property rights as an optional subject, as in what's called one of the non-credit subjects, so that at least an awareness should be there among the students. Second important thing is that one should know the fact that if you come up with a new innovation, okay, the real original thinker automatically gets rewards. So in the today's environment, we are able to see most of the people are realizing about the fact, and that is the reason why, because when the rewards are there, the people used to move towards, and that is the reason why either to get the reward, okay, either to be what's called, so a few people passion might be, to get some recognition. Even in that dimension also, okay, in order to get either reward or recognition, the people used to go for knowing about the intellectual property rights and moving what's called accordingly. And we know the fact that actually it is having a commercial value. Okay, ideas actually, not only the ideas, innovations and inventions, they are having of the commercial value in the today's environment. Once you come up with, then a lot more people are ready to buy your ideas, innovations or inventions. And because of having that commercial value, the commercial value means that the company wanted to what's called get the growth. The company wanted to come up in a unique way. The company wanted to come up what's called to serve its customers, for which always it thinks in a dynamic way. And under that what's called arena, the commercial value what's called is there for our ideas. That is the reason why not we could think about to come out of our ideas. And another important thing is that if you don't want to continue with the existing what's called employer, or else not at all work under any employer. Why? Because one of the surveys which were published in the newspapers on the front line, that no individual, no youth in the today's environment is sticking to the same organization for not more than 2 or 2.5 years. So a survey, what's called, clearly say about of it might be because of a number of reasons. Might be having of a number of opportunities, might be what's called getting the dissatisfaction with the existing employer. So different other reasons, among which whatever the reason that might be, when he don't want to work under any employer and what's called, he don't want to obey somebody's instructions. So if he wanted to be an independent, for which certainly one should come up with his own capabilities, innate capabilities that he's having of in coming up with ideas or what's called inventions or innovations. And another one is, a few people are having much more passionate towards to the research. The person who wanted to involve in the research, certainly there would be some outcome. Some interesting facts that I wanted to share with you in order to come up with an innovation with related to any pharmaceutical drug is concerned, which is not made available on the earth. Okay, it normally it takes 13 years of time. Okay, so even in order to come up with a new a plant seed, for which one should struggle in the laboratory for more than 7 years. It means that how much of struggle that what's called the individual is taking in coming out with a new innovation or invention. So that kind of people is certainly moving the nation ahead because of their passion. When they are coming up with ideas, when the ideas are going to be what's called from the industry point of view as having a commercial value, when it is reaching to the common man, okay, either with what's called certain for a consideration, but ultimately the passion of a person is moving the economy, moving what's called the common man also with the necessities. Next one is actually the technocrats as well as the management, undergraduate and the postgraduates, they are getting a platform. Why? Because in order to, there would be number of career opportunities that you will be having of. But this is a new platform, okay, where if we look into, take the example, I might be having the legal knowledge, but the technical people, the technocrats only will be having the specific what's called core knowledge, okay, with related to a particular product is concerned. So he could only really justify, okay, in writing down or else to come out with, to opt it as a specialized what's called career. Another one is passion towards to give the service to the mankind. Okay, so why? Because we know the fact that a few people, a few companies also in the today's environment, a few business tycoons also in the today's environment, they are so passionate, okay, to serve to the humankind. After reaching to a particular position, especially at the top levels, okay, they wanted to come out with everything. They wanted to donate everything. Why? Because they might have realized about the fact that, okay, what is the ultimate what's called goal of any person? Serving the humankind is what's called a few people when they are having the passionate, either what's called serving in the different areas like as education, health, security, as well as the transportation. So for that reason also, if you really wanted to serve to the humankind, then better to opt IPR as one of your specialized areas, okay, where you could come out with your ideas. And the next important thing is that, as I said, new career avenue, and it is also one of the empowering tools, irrespective of your caste, creed, sex, and what's called other aspects. Every person is going to be empowered if you had the knowledge, if you had the knowledge of innovation or idea, then automatically you would have a market in the today's environment. Now we are stepping what's called, what is meant by the patent. A patent is a monopoly right. Monopoly is nothing but an exclusive right that is going to be granted for an innovation, okay, on a new and useful article, okay, either for coming up with a new process of the existing article or else a new one. One might be getting a doubt that actually what makes the difference in between invention and innovation. Invention is only creating of a new, what's called coming up with a new knowledge. But innovation is something different. You are going to transform of the existing, you are going to transform of an idea or resources into useful applications. Okay, so either for the product or for the process, the patent is going to be granted. Look at actually the granting of patent. Granting of a patent is nothing but getting the recognition from the government. Okay, so either of your idea or principle or else any process, it is going to be valued, it is going to be recognized for 20 years. Actually, why we should go for a patent? Okay, so to protect our creativity, to protect actually our invention, and to get a reward for our invention. These are main 3 reasons for which we should go for a patent system. Interesting facts I wanted to share with you, because when the realistic examples come before you, okay, with the next coming slides, then you might be able to realize about some of the government has clarified that I'm talking about the Indian Patent Act. Indian Patent Act was made in the year of 1970, and then after a new amendment also was made with some of the changes, but actually till we have been following the basic ground definition parts of non-patentable inventions. Non-patentable are nothing but the government don't want to give the patentability or patent rights in these particular areas because it had some reservations. Okay, so the simple arrangement or rearrangement, okay, of the existing either principle or what's called any formula, okay, coming up with innovation or what's called relating to the atomic energy. Why? Because where the secrecy has to be maintained in the interest of public security point of view and public secret point of view. And if an invention or innovation, if it is injurious to the public health, then also the government don't want to give the rights to the patent holder. And the next important thing is that if it is contrary to the natural laws. Okay, one of the examples that I would quote over here, once upon a time, actually our culture never allowed to go for a surrogacy. Okay, so, but after that, on the floor of the parliament itself, okay, so because of the requirement, the surrogacy also was accepted. I'm talking about of the natural and somewhat what's called artificial. Okay, so natural law is something different with that of the artificiality. So we used to support in most of our laws clearly say about of natural, okay, rights of an individual, but somewhat artificial when you are coming up with whether that should be accepted or not. So as I said that surrogacy is one aspect where some contrary were there, but later on actually it were accepted, okay, after having lot of brainstorm on the floor of the parliament. And thereafter actually relating to the traditional knowledge is concerned. Some of the already usages are there in the Indian environment because of having the traditions, okay, having a different what's called the practices in the families. We have been using the different what's called plants for the health point of view. So on which if somebody comes and claims the patent, so in that regard, actually, I would come up with the next coming slides where the government came with a new concept called as Indian Traditional Knowledge Digital Library. So it came up with the a new platform where lot of aspects which were there in practice, okay, since a long time, since immemorial time, it is called as antiquity. Okay, since immemorial time when we have been practicing, okay, some medicinal plants for the health point of view, so on which one could not come up in claiming the patent. And next important thing is that basing on the known theory, okay, just coming up with a new theory on the basis of the known what's called theory, it is also not going to be accepted from the Indian patent point of view. And next is the method, either in the agriculture related aspects or the horticulture or related to the surgical procedures. Even the surgical procedure also, in order to give the relief to the patient, whatever the procedure that you have been following during the surgery, on which one should not claim for the patent. Okay, so with regard to the horticulture and the agriculture also, the same what's called the practices are there with regard to the Indian Patent Act is concerned. The patent can be understood actually, with three types. One is utility patent and the design patent and the plant patent. Utility patent is concerned, it is a new useful process or what's called coming up with a new, equipment or a manufacturing process, which is going to be granted for 20 years for your, original innovation is concerned. I'm talking about innovation. Second important thing is that invention point of view, if you come up with a new design, okay, just I would come up with one of the examples here. Okay, what is a utility patent and what is a design patent? Utility patent is nothing but when you are coming up with the usage of the existing things in a new innovative way, okay, that is being called as utility on which you could have a patent. Okay, though you might have been using what's called a pencil and what's called eraser, but a pencil with an eraser, okay, when you are coming up with a new usage, a new utility point of view, then on this particular process, you might claim your patent. That is being called as a utility patent. And design patent is concerned,
Sir,
how, yes.
sorry, sir. Sir, is the fifth slide is running, sir, now? Sir, sorry for disturbance.
Okay.
Shekhar, sir.
Yes.
Yeah, okay, sir. Resume slide I am getting. Is it right? Okay, right.
Design patent as of now.
Okay,
Is it,
sir.
is it the same that you are visualizing?
Main types of intellectual property, right? We are getting, sir. Screen.
Okay. Actually, here on my
Sir, Rashika sir,
yes, sir.
see, you have shared PPT rather than that presentation.
Presentation.
Share that presentation.
Yes, sir. Yeah, now we got.
Are you able to see now the utility patent?
Yeah, now
Yes,
now it is visible, sir. Right.
Okay. Actually, because of the snap time in between of my moving as well as what's called there, because of the technicality, you might not be able to see what I am able to.
Absolutely. Right.
It might be.
See, we have shared a PPT window, sir, not just a presentation window.
Okay.
PPT presentation window.
Okay. As of now, are you able to see this utility patent?
Now we are
See,
good. Utility patent.
so
Okay.
we can see PPT.
Yeah.
Now we are we are seeing PPT.
Yeah.
So, utility patent, I think that you understood. So coming up with new way of, utilizing of the existing things on which the utility patent is going to be granted. The design patent is concerned when it is, coming up with a novelty or newness and having an aesthetic view. It means that a beautiful look also is required. And besides that, it is a very simple procedure to get the design related patents, for which coming up with making an application with different 7 side views of the product. Okay, the front side, back side, top and bottom. So with which we could make an application. So design is having an aesthetic view, okay, having a beautiful, so it could also be granted with the patent rights. And look at actually this one example that I could come up with, okay, how actually a bottle design, because once it is claimed, no one could come up in the same manner. Okay, with the same bottle design, no one could use it. Just by looking at the bottle shape, a consumer or customer might be able to understand that, yes, this is a product of Coca-Cola. So in such a way, actually, it is creating a value in the market. Actually, the patent procedure is much more simplified in the today's environment. Once upon a time, only approaching the attorneys, approaching what's called the persons who are having the legal knowledge. But here also some of the constraints are there. Okay, the procedure is very simplified, making what's called an application even of a silly idea also. Here actually I wanted to once again acknowledge the central government's initiative, okay, coming and encouraging of the new startups. Okay, so a lot of connectivity is there in between the startups as well as the patent related. Why? Because once you come up with invention or innovation, then certainly it has to be patented. Once the patent is get, then only we could have some royalty payment, the commercial value. In turn, we are going to have what's called the publicity among the people also, and especially on the international platforms. In other countries, simply they used to verify the different patents that are granted, and the same manner they used to even give due respect to the patents already granted in the different countries. As I said that actually the patent related rights are concerned, this could only be called as territorial rights. It means that these are going to be granted only within the territory or what's called a jurisdiction of within four walls of India. So if you really wanted to have the protection at the international level, as I said that WIPO platform is a World Intellectual Property Organization platform is a on which we could register ourselves. The procedure is something different, but the protection among of the different countries for which somewhat it is costlier, but actually it depends on the strategy or the decision of the company where it wanted to register. The simple concept is that if my product is only saleable within four walls of India or within a particular geographical location, then I would only prefer in getting the patent at the local. Okay, so just approaching the register and making an application either through online or offline. Here also, as I said, that some of the constraints are there. I would just come up in the next coming slides some of the constraints. So here, making an application of the patent. An interesting fact here is that if you had any silly idea, okay, so as of now, you might not really be realizing about that, whether it could, whether am I coming with a new idea or not, for which I should go for a search. I should go for a search on the platforms, okay, either on Indian Intellectual Property Organization or else at the WIPO. There is a separate link is there to go for a public search, so that we are going to get the knowledge about actually what is happening, what type of patents that are what's called granted already, which are going to be lapsed. Lapsed is nothing but which are coming to an end, and on which the recent what's called applications were made, so that we would know about actually what the today's market and what the people require. And when I get an idea, when I'm going to register, okay, so I would be given of 18 months of time, within which I should come up with a prototype. I should come up with what's called, exhibiting what's called it to for the examiners, and I should be able to come up with the due explanation. I should justify actually the grounds, and I should claim that actually it is not a violation of, it is an addition. If it is a, you know, innovation, then I would say that actually this is the actually past product, and with which as of now I developed this in this way. So then after the verification, due verification, then it could be put for the, you know, pre-grant opposition. If it is going to, just before publicizing it, it is going to be put to the public at large. Why? Because if anyone comes as a violation of their existing patent, they could come up and they could raise the dispute, or otherwise the grant, what's called, or a refusal, the examiner is going to, you know, finalize it, and then after it is going to be publicized. And the post, what's called, grant opposition also is introduced from the Indian context, and on par with the international norms. Okay, so actually how it is going to be, you know, even after granting of the patent also, why and the government is allowing the raising of the disputes in this regard. Some of the interesting facts are there. I will discuss just in the coming next slides. But actually, what type of rights that a patent holder, actually he would be called as a patentee. Okay, so what type of rights that he could enjoy? So he could exploit, he could use and develop. Okay, so why? Because he's being the owner of that particular intellectuality, so he could use and he could develop in any dimension, and he could exploit in the market. He could, you know, go for manufacturing process. He could, what's called, you know, deploy of his resources on it, and he could sell. So in such a way he could exploit it. So, and the next important thing is that a few people who don't have the viability to go for manufacturing, they might assign or what's called give the licenses to somebody else, so that actually they would earn some money as a royalty payment. Okay, some of the occasions, interesting facts also, what's called, from the Indian context. A few companies which are coming up with the different, you know, patent applications, they are surrendering to the government. Surrendering for the different reasons, either for the security reasons or for what's called public health point of view. Okay, so though you might have a patent, though you might have what's called having the eligibility to, you know, get the patent, but because of some constraints, because of the objections raised by the examiners, they don't want to give. Okay, so but under those occasions, it is also the right is vested with you. That is the reason why here I mentioned it as a right to surrender. Okay, so you could only surrender it. No, none of the other person is able to surrender it. Why? Because you are the innovator, you are the, you know, owner of that particular intellectuality. If somebody uses it without your, you know, permission, without getting what's called any license from you, without paying any royalty payment to you, then you could go for, you know, making an application in the courts, that is called as sue or suit. Okay, it is a civil complaint given in the courts for the infringement, for the violation of your rights. Next important thing is that right to sell or gift of your patent. So being as owner, you are having every right to sell it as well as gift. So as of now, we are able to realize a lot of companies which are especially the startup companies, which they realize that they don't have the viability to go for a manufacturing, and simply actually they are selling of their patent, as well as, you know, from the employee point of view, whenever the controversy is there in between the employee as well as the employer with related to a new process or product or design patent is concerned. Okay, so the settlement, the outcome of the dispute is resulting in giving the gift from the employee to the employer. Okay, the interesting concept here is that compulsory licensing system. Intentionally, actually, some of the governments, they came up with this particular concept called as a compulsory licensing. It means that, take example, if I am the patent holder, okay, so it is of my option whether to give the license or not. or else if I am having the viability, then I would only go for manufacturing process, indulging in the manufacturing processes. But some of the occasions you are compelled to, give the license. The reasons are, the first one is, if you were what's called, because the next slide consists of the one of the examples, okay, where from the Indian context we are able to see why the compulsory licensing system is being introduced, the justification that we are able to see. Here the reasons for the compulsory licensing system is, if it does not satisfy the reasonable requirements of the public. Okay, it means that though it might be useful, but it is not useful in this particular present manner. Okay, or else the way through which you came up with. And second important thing is that if it is not available to the public at a reasonable, affordable price. Okay, and another important thing is that if it is not worked in the territory of India. Okay, so here one of the examples with regard to the compulsory licensing system, Bayer, actually the American company which manufactured the Nexavar, it is an anti-cancer drug for a price of actually 2.8 lakhs from the Indian rupee point of view for a monthly treatment. It looks actually very abnormal from the Indian government point of view, and asked, actually it is a company of the American company, and the Indian government insisted to give a compulsory license to the Indian manufacturing company. Okay, so among which actually Natco Pharma, which came forward. Of course, the government has given option to other companies also. It is an open bid under which the Natco Pharma, which came forward and assuring to provide the same what's called the drug on for a rupees 8,880 rupees per month. And besides that also, actually it wanted to come up with certain exceptions and certain exclusions from the Indian market point of view. Okay, as I said that actually the traditional knowledge digital library, which was initiated by the central government, actually this is the homepage of the traditional knowledge digital library, which was established in the year of 2001 with the collaboration in between the Council of Scientific and Industrial Research under the Ministry of the Health and Family Welfare. Actually, a lot of issues are there relating to the biopiracy, unethical what's called the patents. So biopiracy, just I would come up with certain examples. Though everyone what's called the talks about of the Indian traditional knowledge is being utilized by somebody else, and they are claiming the patents. A lot of violations that we are able to see with regard to the Indian traditional knowledge utilization is concerned. So the government came up what's called this initiative. The different what's called 70% of the population of India, actually when they have been utilizing like as what's called different substances of the Karela, Jamun and Brinjal under the for the different medicinal related aspects, so which have been already being granted as patents by the foreign countries. Okay, so as of now, because of the initiation in the year of 2001, now we are able to come up with a digitalization of the existing usages, existing traditional values. Okay, digitalization is more important actually, on which the government concentrated. We could proudly say that actually as of now, we are able to give this traditional knowledge, okay, without claiming the patents on it. Of course, some of the cases are there where some of the patents which are already granted, against which the government has been fighting with, and in a few areas we are able to get the success also. Look at actually as of now, this traditional knowledge is being shared with 13 major patent offices. Actually, these are the offices where a lot of patents what's called are under the registration. So that is the reason why I'm only quoting of 13 major patent offices with which we are sharing of the traditional knowledge on which they should not claim on, they should not come up with what's called any patent. And look at actually some of the issues that we are able to see. The neem tree is concerned. Okay, so the traditional knowledge, how we used to use the neem for the different, practices point of view. In the year of 1985, the patent 1971, one of the persons from the America, so he made an application to get the patent, and it actually, from the Indian context point of view, we used to say it is a biopiracy, because already the content, already the plants which have been under the usage for the medicinal values, on which if you are coming up and claiming the patents, so which is not acceptable from the India point of view. That is the reason why India came up with what's called the digital library of sharing of the information, and the judgment which clearly says that they accepted the India's argument. Okay, first important thing is that which were already granted previously on the different, not only of the neem, the turmeric also, okay, which was where we had a traditional, utilization. So a lot of issues that we could say, a lot of examples could also could be said, but certainly we could appreciate the central government initiative in digitalizing of the different practices, the traditional practices of India. But here a lot of constraints also are there. And another, actually, the aspect that I should touch up here, the startup related what's called aspects in India and its relevance with the patent system. The government of India, when it is came up with the Startup India initiative, okay, so on 15th August, when the Prime Minister of India has announced, and since 2016 onwards, when it came to the realization about of the encouragement for the new startups, okay, including of the funding support and giving the incentives to the new one. So with regard to the actually startup is concerned, interesting facts that we are able to see from the site itself. So I have taken it from the same actually startup, the government initiative website. In the year of 2016, when it was initiated, 15 actually it was launched, and the 16 onwards, the realistic practice that we are able to see. In the year of 2016, we are able to see 504 of what's called employment, 17 by jobs created is 4.9. It means that 49 what's called 1,000 of people were employed in the new startups. 2018 is concerned, 96,000. 2019, look at actually the incremental growth that we are able to see from the employment opportunities point of view. And with regard to the filing of the startups is concerned, filing of the patents under the startups, okay, we are able to see the abnormal growth from the Indian context. 504 in the 2016, okay, 17, look at actually 5,425. Okay, so now it is only up to 2020, 14,740. It means that every new startup, okay, registration with the government is nothing but filing of a patent. That is a simple what's called aspect that we could understand it. So with regard to the startup practices in other countries are concerned, only USA is just ahead compared to what's called India is concerned. Look at actually 12,556 what's called startups by the year of 2021. So we are as of now, lot of concentration from the government in funding, as well as in giving every type of support to the startups. And some of the, certainly we could see the failureness because of the people are indulging in the random innovations. It means that whatever they like, they used to go for concentrating on, they used to involve in the research and development activities, and they are coming what's called with the innovations on their own interest point of view. It is not up to the expectation of the market. So it is of only personal interest on which they are coming up with the innovations, and that is one of the reasons for which actually
Hello. Sir, is it on? Hello. Sir, okay.
we could realize about the futuristic market. So the market should be ready by the time only on that particular moment only we could come up with. And another important factor is that major failure of the startups are what's called the patents are concerned, because of the patents are once the patent, what the new innovation came up with, they are under the wrong impression that whatever they are coming up, certainly it could be saleable in the market. Okay, so whether or not actually, because the people requirement, the consumer and customer requirement, the alternatives that are what's called made available in the market. So a lot of factors impact would be there. So one should not be under the obsession that so what I come up with, certainly it would be marketed. Okay, lack of funding also. So as I said that though the initiation was made by the central government, okay, with regard to the encouraging of the patent applications with regard to startups is concerned, but every company that is coming up in the realistic manner for the manufacturing to the market, so by the time it is facing the financial problems, so we could say that certainly the funding might not be made available with everyone. There actually they are getting what's called the infant problems. And actually what are the strategies to overcome of these problems with related to the startup as well as the patents are concerned? First, actually just before patenting, okay, just before what's called going for even an innovation also, involve or indulge in the research process. Okay, search on the national and international platforms what is happening and on which actually the present patent applications are moving. Okay, it means that it shows actually the market trend. Okay, so one should try to come up with the ideas and innovations which are usually user friendly as well as good looking, and it should be able to solve the crucial problems of the society, and it should also be concentrated on the cost effectiveness, or otherwise the availability of the consumer and customer makes a lot more impact on your product. Okay, the patent drafting is one of the important aspects. Of course, actually though online the process is being made initiated by the government, patent filing is made online very easier, but practical difficulties are there. Why? Because while what's called filling the application, if I without knowing the knowledge, if I claim something, okay, it might be becoming as a narrower claim from the longer point of view. Okay, so when the narrower claim is made, though you innovated, but you are not claiming to that extent up to your what's called capability point of view. So another one is actually lot of initiatives from the government side in helping extending the help. So specialized agencies are there, so you could knock the door of these specialized agencies which are going to be helpful to us. Okay, so anyhow, actually thank you for giving this opportunity. Handovering to the co-coordinator.
Yes. Thank you very much, sir. You have delivered a very good and invaluable content with excellent presentation today. Definitely, it will be useful to our students and the faculty in their so bright future in order to innovate or something. We expect similar services from you for our further webinars or conferences.
Sure, sir. Thank you, sir. Thank you very much.
I also thank all the participants and organizers, co-coordinators who made this program very successful. So thank you once again to all.
Thank you, sir. Thank you, sir.
Rajshekar, sir.
Thank you, sir. Thank you very much.
Thank you very much, sir. So nice meeting you.
Nice to meet you, sir.
Thank you, sir.